Colleagues, thank you very much for coming back after the lunch. Great to see the video. I've got two tasks before I introduce the panel. One is, we promised you an update on the travel. Our intelligence insight, which is probably no better than anybody else's in the room, is that probably getting around London is going to be fine. If you're going somewhere out of London, obviously you need to check with your own provider, I guess is the right word. However you're traveling, check it out. It's very variable across the country, but London seems to be, the prospects are good. So we're going to go through to the end of the programme. Obviously we understand if there are people who need to go and get a train or whatever they need to do. And we are hugely grateful that people have made such a commitment to being here, given the state of the weather. My second task is, if I could ask these three students from the Royal College of Music to come and join us on the stage. They were playing right through your lunch. It was absolutely fantastic. Thank you all of you. And there are lots of students who can play almost as well as that all over the country in the conservatoires and so on, and sometimes in schools of music, and we are thrilled to be supportive of the kind of dance you've just seen, the kind of arts that you've just seen, and the music that you heard over lunch. Next, now this is possibly the moment you've all been waiting for. The publication of the regulatory framework is published today. You'll be able to find it online. The panel has three members: Martin Coleman, Deputy Chair of the OFS, top lawyer in competition and other law, and a wonderful contributor to our board over recent months and into the future. He's been leading a lot of the work here. Susan Lapworth, who some of you will know from HEFKE, who we're delighted, joining OFS as we're created at the beginning of April, and has been leading the work with a considerable degree of heroism on getting the regulatory framework out, and we're all deeply grateful to Susan. In fact, I might even ask if you could just give Susan a round of applause for the work she's done on this. It's a tough job, and the consultation's been really thorough, and the work's been really excellent. And then finally, Nicola, who needs no introduction because she was up here this morning, but obviously has been leading the work. So Nicola, Martin, and Susan, if you could come on the platform, that'd be great. Do you want me to stay or? I think better, yeah.
Well, having been subject to the snow for a lot of this morning, I'm particularly pleased to be here. At one point, I did envisage giving this talk from a train carriage with, via Skype with the other passengers joining in. But I'm going to start this session to talk about the policy underpinning the new regulatory framework. Nicola will then describe how we developed the final version of the framework, taking into account the very valuable comments that we received. And finally, Susan will talk about what happens next. Our new regulatory framework seeks to ensure that all students with potential and who wish to benefit from higher education have a good choice of diverse provision offered by autonomous providers in a system that meets student and public interests. The system currently has many great strengths and excellent providers. It also has some weaknesses. Our aim is that the system should build on what works well, but where change is desirable, providers old and new should receive the appropriate signals and have the incentives and the flexibility to react. And as a regulator, we've been ambitious in our aspirations while appropriately modest about our role. Ambitious because regulation can raise standards and support positive change. Modest because regulation is no substitute for the energy, innovation, and creativity which comes from those on the ground. There are 4 core elements to the new system. First, baseline conditions to protect students and public interests. Second, targeted interventions to advance specified student and public interests. Third, freedom for institutions to determine their own path. And fourth, the OFS leading discussion on best practice and the future role and shape of the sector. I'll talk about these elements individually, but they are all part of a connected framework, high-quality and varied provision developed by providers making autonomous decisions underpinned by baseline conditions and learning from experience elsewhere. At the core of the new system are baseline conditions to be satisfied by all registered providers. The baseline is just that, a floor to ensure protection for students and confidence in the system. The baselines describe outcomes. How the outcomes are achieved will reflect the diversity of provision, with each provider responsible for shaping its own distinct offering. An important baseline would ensure that students can be confident that a registered provider will deliver well-designed courses that provide a high-quality academic experience with reliable assessment. Other conditions include safeguards that students receive what they have been promised by their provider, and appropriate student protection in the event of course or institutional closure. Our conditions will in the main apply to all or most registered providers, but in some cases we might impose specific conditions on a particular provider based on our risk assessment at the point of registration or information that comes to our attention after registration. For example, if a provider is an entity within a wider corporate group, we might want to be sure that financial sustainability is properly addressed. It is for each provider to decide how to meet the outcomes set out in the baseline conditions. There's not a one-size-fits-all. What is right for one institution will not be appropriate for another. That said, we are aware that particularly with a new regime, it is helpful to have some indication of behaviours that may satisfy each condition and those that might not. We've therefore included in the regulatory framework indicators that might demonstrate compliance and non-compliance with each condition. For example, one of the indicators that a provider is meeting the financial viability condition is that it has a history of accurate financial forecasting. An institution might therefore seek to review its forecasting mechanisms to help ensure compliance with this condition. But how it does that is a matter for the provider. An approach that is suitable for one may not be appropriate for another. And the significance of the indicator will vary between providers. So for a relatively new provider, the financial forecasting track record may matter less, and other criteria, such as content and extent of current financial facilities, matter more than for a long-established one. So what happens if a provider breaches a condition? Remember, our main concern is to protect the interests of students. The best way to do this is to avoid infringements through the early identification of potential risks, and that's done by a combination of effective monitoring and a trusted relationship between the OFS and each provider. But sometimes that will not be enough. Where relevant data or other information indicates a material risk that a provider is not meeting conditions, we shall consider intervening. Not all breaches will be of the same level of seriousness. There's a spectrum. At one end, deliberate and sustained infringements with serious consequences. At the other end, a one-off error with very limited impact on students. We should always have regard to the specific circumstances and impact when considering the best approach. And we have a range of measures at our disposal, including enhanced monitoring, additional conditions, and in the most serious cases, suspension or removal from the register and monetary penalties. Now, these are powerful instruments with significant consequences for providers. We shall not hesitate to use them where necessary, but they should not be seen as the norm. And transparency, of course, is also an important regulatory tool. The second element of the system is more targeted intervention. So while the baseline set out the minimum, albeit strong, requirements, the targeted interventions, some in the form of regulatory conditions also, will be more specific in bringing about change and improvement. They will be limited to areas where individual initiatives by providers will not be sufficient to advance important student and public interests. Foremost is ensuring that all students who have the potential to benefit from higher education and wish to do so have access to the full range of institutions and courses and are properly supported to fulfill their potential. All institutions in the fee-capped part of the register, and which admit students entitled to receive the highest tuition fee loan, will be required to have an access and participation plan approved by the OFS. And this is more than a baseline. The plan will seek to drive continuous improvement in admitting students from disadvantaged and underrepresented groups and supporting the retention, attainment, and progression of such students once they arrive. Another area for more direct intervention is where certain skills are needed for society as a whole, and because of cost or other reasons, additional support is required to ensure delivery. Beyond the baseline, institutions, not the regulator, are best placed to make decisions. Some will build on a long history to craft their future provision. Others will be new and seek to identify areas where need is not currently being well met, such as provision for mature students. Many will innovate, for example, in how they support students, the type of courses they offer, the length of courses, where they offer them, relationships with employers, and the way they teach. In doing this, they will increase opportunities for students and ensure the health and vitality of the system. Our role will be to encourage and support such initiatives and make sure that students receive useful information and signals, for example, through the Teaching Excellence and Student Outcomes Framework and the Longitudinal Educational Outcomes Dataset. It's this aspect of the system that is closest to a market, with providers seeking to deliver strong outcomes, innovate, and differentiate in order to attract students. But to be clear, it is a regulated market, as is appropriate for a sector delivering both public and private goods and serving some vulnerable users. The baseline conditions and the more targeted interventions ensure that the benefits of choice and responsiveness to change and new ideas that come from a well-functioning market are combined with appropriate interventions and protections for students and the public. And because so much public money is invested in the system and students incur significant debt to meet providers' costs, it is not unreasonable that we require providers to give proper weight to matters such as student engagement, good governance, and effective and efficient use of resources, and that they are held to account for how they do this. Accountability is facilitated by transparency. Providers will be required to publish specified information on matters such as senior leadership remuneration to enable students, staff, and the wider community to understand and debate how valuable resources are being utilized. Finally, The OFS will have a unique oversight across the sector as a whole, including non-registered providers, and power, for example, through thematic reviews, to examine what works well and not so well sometimes. We have a duty to monitor and report on financial sustainability. We shall spread best practice and engage in thought leadership, recognizing that in doing so, we shall have a distinct perspective, but others will also have valuable perspectives. Now, there are those who say that this system, with its 4 elements, is insufficient, that relying on outcome-focused baselines and limiting direct intervention to a number of high-priority public interest areas is not enough. They challenge the market elements of the system, want a more interventionist regulator that will set the agenda for the sector as a whole and help protect it from the forces of change. And there are countries that have a centrally planned higher education system. But one of the strengths of the English higher education system is the autonomy and diversity of providers. The success of English higher education is not because of state direction, but reflects the efforts and initiatives of our institutions and those who work in them. Regulation is an important adjunct to institutional decision-making, but not a replacement. Baseline conditions would ensure that there is proper institutional planning. What is in those plans is for independent providers to determine, taking into account the needs of present, past, and future students, research objectives, and the value of wider engagement. There are others who see autonomy as meaning that regulatory oversight beyond the bare minimum, such as protection of the university title, as illegitimate. Providers should be left to advance their own concerns, taking into account wider interests as they see fit. We agree that there should be vigilance against unnecessary intervention. But the idea that institutions should be the sole guardians of student and public interests fails to acknowledge the need for accountability of a sector which serves critical social and economic objectives and in which huge sums of taxpayers' money is invested. It also doesn't recognize that although there is significant alignment between the interests of students and providers, those interests can sometimes diverge. The protection of students is a proper regulatory objective. So our new regulatory system treads a careful path, protecting vital student and public interests while understanding that central planning is inimical to a good quality, diverse, independent, and vibrant sector. The freedom of institutions to make their own decisions is essential to ensuring that the system is responsive to student needs. Now, this requires prudent judgments, and we will not always get it right. There may be occasions when our regulatory approach might, in retrospect, have been more burdensome than necessary, and others where we could have intervened sooner to address specific concerns. But our means of travel is clear. Protection of student and public interests through baseline conditions, advancement of specified student and public interest through targeted interventions, institutions determining their own path within and beyond these parameters, and the OFS leading thinking about best practice and the future role and shape of the sector. Thank you.
Thank you very much, Martin. I'm now going to say a few words about the process that we followed in analysing the responses to the regulatory framework consultation, and there it is. Many of you will recognise those covers probably only too well, and how we translated the consultation responses into the regulatory framework that we're launching today. We received over 300 consultation responses. And can I thank all of you who did take the time to submit some really thoughtful observations in those submissions. And I think it's undoubtedly the case that the regulatory framework that we're publishing today is stronger as a consequence of your views. So our full, I should say that the full analysis of how we've responded is set out in a document which is on our website, the narrative response, and that's at the bottom of that slide. I'm just going to pick out a few of the main themes. And overall, there was broad support for the proposals, so clearly many different views expressed within there. And the 65% agree, 24% disagree is actually taken from the specific question as to whether or not you thought we'd correctly identified the risks to students. But that is broadly reflective of the responses across the piece. You will notice that doesn't add up to 100% because there's quite a few people who were neutral in the middle in terms of that question. There were concerns expressed about the proposals in relation to the registered basic category. And you'll remember that this was the category which had few requirements attached to it, but nonetheless it would signal registration for those providers. Many of you who responded were concerned that its formulation was orientated around benefits to the providers in getting on the register rather than protections to students. And there was this overwhelming sense that being on the register was some sort of kite mark and that it could therefore be misleading to have this registered basic category, which could be misunderstood by students. And we took the view that there was merit in that argument, and therefore we have deleted the category, but we have committed to undertake work with those unregistered providers to better understand how we at the OFS can play a role in protecting their students, and that's work that we will be taking forward. Another common theme that actually came not just from student representatives, but what beyond as well, was that we hadn't adequately required providers to actively engage with their students, in particular through the governance arrangements. And we agreed with this point, and therefore you'll see from the document that we have included in it, in the public interest governance principles, a requirement that, and I'm quoting here from the text, the governing body ensures that all students have opportunities to engage with the governance of a provider, and that this allows for a range of perspectives to have influence. And then further, in assessing whether or not a provider has complied with this principle, evidence that we may take into account is stated to include whether or not there's a student member on the provider's governing body when that's appropriate. Different views were expressed about our proposal to adopt a risk-based approach to regulation. The National Union of Students and several student bodies argued that without regular checks, the framework wouldn't protect all students. Whereas other respondents argued we should go further and that some conditions should be entirely disapplied to compliant providers as a way of reducing regulatory burden. We've broadly decided to stick with our proposed approach, as Martin has just outlined, though we are actively considering how we can ensure a commitment to remove unnecessary regulatory burden, if not in the transition year of 18-19, certainly after that. Differing views were expressed on senior staff remuneration. Over 80% of student representative submissions agreed with our approach to include a registration condition that related to senior salaries, compared to just over 30% of higher education institutions' responses. We've decided to adopt a robust response here, but flexible. The framework, therefore, references the fact that we intend to include a requirement to disclose details about remuneration packages and justification of senior staff salaries in our annual accounts direction that we'll be issuing shortly, and require compliance with that accounts direction as a registration condition. What that will mean is that our primary regulatory lever, picking up on the point that Martin has just made about transparency and accountability representing an important regulatory lever. So that will be our primary mechanism, but if that fails, the link, the explicit link to registration conditions allows us to deploy a range of interventions and sanctions, and we can take further regulatory action in this area if appropriate. We've also included an additional public interest governance principle requiring adequate and effective arrangements to ensure transparency about value for money for students and taxpayers. And as evidence of compliance, we'll look at whether or not a provider has signed up to the Committee of University Chairs Remuneration Code. Finally, and briefly, in response to the consultation proposals on degree awarding powers and university title, there was again broad support for our proposals, but concerns were expressed about the concept of probationary research degree awarding powers, with 54% of respondents disagreeing with this proposal and only 33% agreeing. And we've therefore decided to remove that option, and instead new DAPs will only be available for teaching. We've also taken account of the reservations expressed by some respondents that established providers would be disadvantaged by not being able to apply for new degree awarding powers on the same basis of entirely new providers who didn't have a track record. And so we've therefore changed the proposals so that now all providers will be able to apply for new degree awarding powers regardless of their track record. So I'm going to finish by just flagging our slightly revised 4 primary regulatory objectives which underpin the way in which the conditions are articulated. These are roughly similar but not identical to the ones that were in the consultation document. In particular, we picked up on concerns expressed by many respondents in the original formulation, which referred to the OFS protecting student interests as consumers. We're not in any sense undermining our commitment to ensuring that student rights are protected and that we are operating in a market. However, we felt that that sort of vocabulary didn't capture the full richness and co-regulatory aspect of students' relationship with institutions. We heard so clearly from the presentation just before lunch on value for money. So we've changed the wording there to, as you can see here, ensuring that their students' interests are protected whilst they study. So there we have it. This is our new regulatory framework. It's an awful lot shorter than the proposals in the consultation, pretty much half the size of it. We've stripped out a lot of the vocabulary. It's a lot, I hope, easier to read, and we've made many other changes. As I say, the details are set out, obviously, in the regulatory framework document itself, which is available on our website. You've all been given a summary of it. And the explanation as to how we got there is set out in the narrative response, which is on our website. I'm going to pass over to Susan at this point to take us on to next steps.
So what happens next? Along with the regulatory framework, we've also published today guidance about the registration process for providers of higher education. There's a set of guidance for new providers, so those who've not been regulated before, and a slightly different set for those of you who are currently regulated. They're on the website with the regulatory framework, so do go and have a look at those when you have time. If you're a provider, you'll need to register with us if you want to access certain benefits. So if you want to access public grant funding, either from the OFS or from UKRI, you'll need to register. You'll also need to register if you want your students to have access to the student support system, or if you want to be eligible for a Tier 4 licence from the Home Office, or if you want to apply for degree awarding powers or university title in the future. We'll start the registration process at the beginning of April, and I'll talk in a second about what the timeline for that looks like. During registration, each provider will need to demonstrate that it satisfies the initial conditions of registration. And you've got the conditions inside the hard copy summary that we gave you. They're towards the back of that document. As we make that assessment, we'll use some evidence previously collected in the old regulatory system. So, for example, if your financial sustainability has already been assessed this year, we'll use the information that you already submitted to inform our registration process. So we're trying to make sure that you don't need to give us more information that's already been provided. We will, though, need to ask you to provide some new evidence, and I've put the items up there on the slide for you. You'll need to submit an access and participation plan or an access and participation statement. We'll need a student protection plan from you that says how you'll protect your students if their course or their department or their campus closes, or if for one reason or another you're not able to continue to offer higher education. We want information about how you take into account guidance on consumer protection law, and we'll want some information from you about your management and governance arrangements. If you're a brand new provider, you'll also need to give us evidence about your financial sustainability, and you'll also need a quality and standards review visit by our designated quality body, that's the QAA. We've provided details of all of this in the guidance that we've published today, and we've tried to do that in a way that makes it easy for you to understand what we need you to do and how we need you to do it. Here's the way that the timeline then unfolds over the next few months. We're holding a series of briefing events during March. There'll be 2 large events and a series of smaller activities. We're also accepting as many invitations as we can to come along to events that others are holding. So do please get in touch if you'd like to invite us to come along and talk about this at an event you have planned. We'll be able to accept applications for registration from the 3rd of April, and you can apply any time after that. We're aiming to make registration decisions first for providers with early applicant deadlines for students. And we're trying to do that so that information about your registration status is available for your students as they're making choices about where to study. So we'd like those applications by the 30th of April. For those of you with standard student application deadlines, we'd like applications by the 23rd of May. But these aren't absolute deadlines. This isn't a guillotine. You can apply at any time and we'll still assess your application. And there's more detail about all of this in the guidance that we've published. The last thing I need to say is that registration with the OFS relates to students and funding arrangements from the 1st of August 2019. This means that if you're currently regulated by HEFCE or by the Department for Education, those regulatory requirements will continue to apply during the next academic year. We plan to publish later in March more information about how that transition year will work, so how we will regulate using both old powers and new powers. So do look out for that more detailed guidance. I'd normally pause for questions, but I'm afraid we don't have time, and I'm sure you're bursting to ask questions. So do come and chat in the tea break if you'd like to today, or do contact us, invite us to events, or ask any questions that you do have once you've had time to read the full regulatory framework. Thank you.